Your Honor, that I hope you realize is not possible for me. I'm even being harmed waiting for 2.5 hours on my cell phone, which is on speaker remote from me.
Then I don't know how I'm going to get you into court.
October 4th of this year, I gave the defendant the proper 30-day notice demanding possession of my property because of non-payment of rent.
Well, okay, let me stop you there.
Okay.
A 30-day can't be the subject of a non-payment of rent action.
Okay. So.
All right. Do you want her to move, or are you just terminating her tenancy? I mean, are you terminating her tenancy and want her to move, or do you want her to pay you?
I want her to move, and I want to also have a money judgment. So I can't do that?
Yes, you can do that.
Okay, that's what I want.
Okay. Go ahead.
Yeah, and I'm seeking a money judgment from the court for all back she owes me as of December 1st, 2023, which is $11,995 plus court costs $215 and service fee of $68.
So how much is the
So the total money judgment requested from the court is $12,278.
All right, guys, buckle up, because this hearing starts messy right out of the gate. We jump straight into confusion, frustration, and procedural chaos as the landlord lays out an eviction and money demand, only for the judge to immediately step in and correct the legal approach. From the very first minute, it's clear this isn't going to be a smooth case. The judge sets the tone, the landlord adjusts on the fly, and the tension is established instantly.
All right, Ms. Gerler, what do you have to say to that?
Your Honor, when I first moved in, it was to be a temporary arrangement. I had another place lined up that did not end up being represented appropriately. It was to be vacated and renovated. Didn't happen. I have attempted along the way to give Ms. Peel, the plaintiff, money. I became extremely ill with COVID, which I have long COVID, along with 2 other disabilities. When I became behind in rent because of illness and sought help from local agencies, the plaintiff was offered money from Faith in Action, and she declined those monies. And there were other monies from other agencies that would have been available that would have satisfied my arrearages at that time of $2,985. Declining those monies led me to believe that she simply wanted me to move out. So I tried to start packing possessions, became ill with COVID again. I have, in the court documents, outlined to you the many times since then that I have been afflicted with every COVID variant. I already have a serious, extreme condition of electrohypersensitivity that I cannot easily find a place to live. I cannot live in group settings, be exposed to Wi-Fi, wireless meters, be near cell towers. I need a rural environment.
Here's where the emotional defense takes center stage. The tenant responds with a detailed explanation about illness, long COVID, disabilities, and financial hardship, framing the unpaid rent as a consequence of circumstances rather than choice. This section slows the courtroom down and forces the judge to listen, while viewers are left wondering whether sympathy will outweigh the landlord's legal rights or if the explanation is setting up future problems.
I no longer have a vehicle. I cannot use cell phones, smartphones, computers due to my electrohypersensitivity, and I thank the court for granting this Zoom appointment at the last minute, since I was not supplied the forms necessary in the personal and mailing service I received. and was actually waiting because in our December 1st hearing with Judge Barr, he informed the plaintiff that she had filed incorrect paperwork and needed to refile. So I have been waiting for that paperwork to come, which I don't know, something changed and was not necessary. But
What incorrect paperwork? I don't have a notice to that.
Well, and that's whatever happened, Your Honor. That's what I heard in court, and I'm not privy to what happened thereafter. I am chronically ill, Your Honor. When I get well,
Ma'am, hold
I
on.
cannot work.
Yes, ma'am.
I spoke with my attorney counsel yesterday, and she said my paperwork was fine. I think it was just not clear to Judge Barr what I wanted because I didn't know how to present my case. So,
Well,
but
yeah, I actually see what Judge Barr is saying right now. Well, you filed 2 different notices. That's why. I got it. It's fine. I think. Hold on. That's not that one. Right. You filed 2 different ones, but you got, it appears to me, the correct paperwork. All right.
This part spirals into procedural confusion. The tenant claims paperwork was filed incorrectly based on statements from a prior hearing, while the judge reviews the filings in real time and concludes they are actually valid. You can feel the shift here. Excuses begin to unravel, and the judge calmly dismantles the misunderstanding, narrowing the case back to its core issues instead of side disputes.
Your Honor,
So-
just to respond, that's what I heard from the judge. And my legal
Yeah, but
counsel,
this is another judge saying that that's wrong. It's correct.
and that's fine. I have no problem, but I
Okay,
was waiting
good.
on that paperwork. I know that the plaintiff is someone who tries to do things appropriately, but what did not happen appropriately with this home that has been a long time rental is that there is no certificate of compliance on file with the township. And the
Okay, so
application-
when are you going to move then?
Your Honor, I have had to deal with all the demands of the court, so I cannot explore that yet because I was required to apply for SER with the DHS, which was declined. I have contacted every agency available to me thus far.
Ma'am, do you understand she doesn't want you to pay rent and stay? She wants you to leave.
I understand that, sir, but to comply with the court and the paperwork required for this hearing, DHS, that's where I have put my first attentions. I have been packing and moving things out of the house, which they have witnessed, but because of my extreme sensitivities, it is not easy for me to find a place where I can live safely. I have just recovered from my last bout with COVID, which has severely impacted me for the last 4 years and created these issues. And I have also...
Ma'am, I understand all of that. The question becomes, when can you move?
That is a question mark to you and me both, Your Honor. I do not know. I have nowhere to go. I am solo in this world. I have no vehicle. My car broke down June of 2022. And
Now the argument pivots to compliance and housing regulations. The tenant introduces a new defense involving certificates and township rules, hoping it changes the trajectory of the case. The judge listens, but steadily redirects the conversation, making it clear that these claims don't override the central question. The tension builds as it becomes obvious that legal technicalities won't delay the inevitable decision.
my situation is not a good one because of chronic illness. My energy is not reliable. I'm sometimes 12 hours in the bed.
Okay, ma'am, I can appreciate all of that. But you also have to understand that the landlord is entitled to her premises back.
I understand that they request their premises back, and I have an appointment with Hawk on Monday. To what degree that will help, I do not know at this point. I have been unable to find assistance from anybody because they say I am not sustainable, because I am now forced to live only on my Social Security income, the house line.
All right. Okay, ma'am. Here's what I'm going to do, because this has got to... I understand the difficulties that you're telling. I also understand that the landlord needs to resolve that. So I'm going to set this for a trial. You raised some issues in your answer, but...
This is the emotional peak of the hearing. The tenant openly admits having nowhere to go, no transportation, declining health, and limited income. It's raw, uncomfortable, and deeply personal. The judge acknowledges the hardship but draws a firm line, reminding everyone that the landlord is legally entitled to regain possession. This moment captures the collision between empathy and law.
I'm going to set it for a yes, ma'am.
When I talked to my attorney, she said that there is no requirement for the compliance regulations in Webster Township where I live. And she's an attorney from Dexter. So.
Oh, they know
And
more.
that was-
They know more than us here, us other country folk from Pittsfield, or what?
I guess. I don't know. That's what she said. Is that correct?
What?
That's what she said.
I don't know. I guess she's from Dexter, so she knows more than us.
Township does
We're
not
just
issue.
little country judges up here. You know, ma'am.
I actually called the zoning person too. She
Okay,
said-
and she said, yeah, probably
said-
she agreed.
I'm having difficulty hearing, Your Honor. Could that be repeated?
No. Okay. She went to Webster Township. The issue regarding the certificate of occupancy, it really isn't an issue because they don't require it for rental properties in Webster Township. That's the long and short of it.
I would like to know then why Legal Services of South Central Michigan gave me this form and checked
Okay,
it out. They
ma'am.
must
I
have
don't know.
obviously-
You guys keep talking about lawyers. I've not met them. I don't know. All I know is this. You two are in front of me arguing a case. You have one position, plaintiff has another position. So here's what I'm going to do. I'm going to set this matter for non-jury trial. It will be in person.
Here, the judge fully takes control. After hearing competing claims about regulations and legal advice, the court shuts down the circular arguments and makes a decisive move by ordering a non-jury trial. This segment marks a clear shift from debate to resolution. The uncertainty narrows, and the focus moves away from explanations toward formal adjudication and next steps.
Your Honor, that I hope you realize is not possible for me. I'm even being harmed waiting for 2.5 hours on my cell phone, which is on speaker remote
Ma'am,
from me.
then I don't know how I'm going to get you into court.
How is is it not possible for me to continue in this manner, sir? I have been before you to establish the severity of my condition. I become debilitated, incapacitated, ill. I lived in the basement of my prior home for 7 months because of radiation poisoning, and by necessity, where your court is located, there are many electronic communication requirements for police, fire, the cell tower, Wi-Fi for the buildings. I will literally fry and be unable to move. That's why I couldn't come today. this is not a fun scenario. And the landlords are well aware of my conditions. They had mitigated the house. They used Ethernet.
All right, ma'am. All right, look. Do you have any problem if I hold a trial and she appears by Zoom?
I guess not. I've been without income for a long time, and my preference is
Okay, look, folks.
Yeah.
There are a lot of folks out there that are
Everyone
having a
has
hard
sad
time,
story.
and I get it.
Yeah.
Okay, I have to deal with it every Friday, so I don't know that I can help you with any of that right now.
Right.
I'm just trying to set a trial date. Do you have any
better.
objection to her?
Tomorrow?
What?
Tomorrow, the sooner the better.
I'm not coming in on Saturday.
How
This is not happening.
about Monday?
No. What? We can do when? What time? 1 o'clock on Wednesday? Oh no, I can't do 1 o'clock. What time seriously can I do? Non-jury trial, December 20th, 2023.
Yep.
9 a.m.
9 a.m. Okay. And
You need to appear in person. Ma'am, you can appear via Zoom.
right here?
Absolutely, that's where I'll be.
Okay.
And if I don't get this docket done, I'll be still sitting here from this one.
All right. Thank you.
Thank you.
Okay, thank you, Your Honor, for the accommodation for my disabilities. I appreciate your sensitivity to the matter and your humor.
Thank you, ma'am.
Bless you. I will sign off now.
All righty.
The final clash unfolds as the tenant strongly objects to appearing in person, citing extreme medical sensitivities and health risks. Rather than escalating, the judge balances firmness with accommodation, allowing a Zoom appearance while locking in a trial date. The case finally lands on a clear path forward. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.